Welcome back yet again, folks. Aaron Keller here on Law and Crime. Look, we've got a lot to report here in a couple of cases we're following. First of all, in the Kirkland case in Cincinnati, Ohio, jurors in that death penalty rehearing have reached a verdict. We are waiting for people to filter back into the courtroom. This was just announced within the last couple of minutes, as we understand it. So at this point, they have to get all the parties assembled. Everyone has to filter back into the courtroom. And as soon as that process starts, we will listen in live as this defendant, who was either convicted or admitted to being involved in 5 separate killings, will learn whether or not he's going back to death row or whether or not this will be a life sentence without the possibility of parole. Those are the two choices that have been submitted to jurors. They've been deliberating through the afternoon to this point. They had a lengthy pile of jury verdict forms to fill out, some 16 different forms. So even if they arrived at a quick decision, they had a lot of paperwork to fill out back in that jury room. So we are waiting for things to come together in the Kirkland case in Cincinnati. In the meantime, we're following the Stephen Foster case. That's a Georgia case where a man, a doctor running for U.S. Congress as a Democrat, was pulled over and accused of drunk driving. He just gave some contentious testimony in court. The defense recalled an officer to the stand and asked whether the officer wanted to change his mind from an original report which indicated the defendant was swaying during one of the field sobriety tests, because he initially indicated that the defendant was, but apparently the videotape, at least in the defense version, doesn't seem to indicate that. So we're going to break that down a little bit because they've taken a break in the Foster case just within the last couple of minutes. I'm going to bring Michael Bachner into the conversation. He's an attorney here in New York City. Michael, it's been a while.
How are you?
Pretty good. You have been extremely busy. What do you make of the Foster case, though? I mean, this guy is somebody who is a person of some prominence in that community. It's a small community. He's a doctor. He's running for Congress. He says he's out, has 2 drinks, gets pulled over, and somehow winds up at a .103, according to the police. But then one of his contentions is, wait a minute, under Georgia law, I have a right to an independent blood draw, and they refuse to do it for me. That's what he claims.
Well, you know, to the extent that a jury who's going to have to determine whether or not he was drunk or not is going to have some conclusions about whether or not the first test was not reliable, and that a second test, I think the doctor was insinuating, if done at a different type of hospital, is more reliable and would have come out with a result fairly quickly and could have exonerated him. A jury might conclude, you know what, the guy didn't get a fair shot, and we're not just going to go with that first blood test. He did blow, according to that first test, 1.03, which is way above normal, but you know, that's a lot more than 2 drinks that he said he had. But it's going to be for a jury to determine whether or not they think that that's a reliable situation, or the cop didn't give him a fair break. Exactly.
So, you know, look, if the state law provides a defendant with certain rights and then those rights aren't recognized, then really, in many minds, the inquiry ends there. But I want to bring Law and Crime's own Bob Bianchi into the discussion. He's joining us via Skype. Bob, I feel like I'm sitting in your seat. Do I have permission, counselor, to occupy the host chair?
Only if you say you feel a certain scintillation by sitting there, Aaron.
No. Sorry, Bob. But look, what do you make of this Foster case, Bob? I mean, there was a lot of fireworks back and forth in court there from the defense really trying to go after this cop, saying, wait a minute, the video says one thing and you're saying another. And the prosecution seems like it was trying to sort of pull wool over people's eyes and say, oh, wait a minute, that's just on the report. It's not really in evidence, so you can't cross-examine them on that.
Yeah, you know, Aaron, in cases like this, the defense attorney's difficulty, and I'm saying this as a former prosecutor, is that these guys check off the box, slurred speech, red eyes, you know, swaying, weren't able to maintain balance during these standard field sobriety tests. And so obviously a videotape of that and the ability to cross-examine the officer to see whether or not, in fact, that would change or alter his conclusions is always a legitimate area of cross-examination because it goes to the credibility of the officer's observations. And so I'm really surprised that there's even a debate about this. And the second point, Aaron, I would bring out is it appears to me, unless I'm missing something, that I'm surprised these speaking objections are occurring before the jury in many of these instances.
Yeah. Every judge is a little bit different with that. We certainly have seen it here. So just to let folks know, in case you're just joining us, we're waiting for a verdict in the Kirkland case. This was a death penalty rehearing in Cincinnati, Ohio, against a defendant who was previously sentenced to death row for a series of murders. But the Supreme Court ruled that he needed a new sentencing hearing due to prosecutorial overreach. The jury got that case this morning. People are just starting to come back into the courtroom now in Cincinnati. We're waiting to see exactly how quickly they assemble to read that verdict. So let's jump back into Foster now. That case is in a break. One thing that's interesting, and I'll throw this on the table for discussion, and Michael, maybe I'll start with you. We were told that this was going to be a pro se defendant. He was going to represent himself. And then all of a sudden, this defense attorney pops up tomorrow to give an opening statement, and he says, well, like you folks, I'm just sort of getting this case, and I'm going to be kind of going through it with you here. I was cramming to prepare for this, and I'm sitting there saying, did he retain counsel right at the last second, like all of a sudden nervous that maybe he needed a professional on his side?
Yeah,
you love those clients, don't you?
Just wonderful. But at the end of the day, if you're just brought into the case, do your job, be professional about it, and you don't have to start commiserating with the jury about the fact that you don't think you can do a good job, or you're not prepared, or you're sorry, etc. Do your job. He sounds like he's a professional, knows what he's doing. I had the same comments that Bob had. You and I actually had commented with each other about, is this in front of a jury or not? Because I thought it was very unusual also. These speaking objections that are being made are very unusual for a judge to allow it, but it looks like this judge is actually interested in having it happen. It's very unusual to require a lawyer to start vocalizing the basis of his objections in front of a jury. It's just a little weird. You
know, this might be one of those cases where you've got a defendant who seems like he was sort of running off in the direction that perhaps counsel didn't want him to run off. So maybe they had to just jump in and throw the objections on the table because there was no other way of sort of reeling the situation in. Bob, I'm curious, so we've got about a minute before the break. Do you take that away from this as well, or do you think I'm completely clueless?
With respect to what, Aaron?
As to what's going on with the speaking objections, as to, you know, look, you've got a client on the stand who seems like he's pretty adamant about telling his own story. And if you're examining him, you kind of have to hone him in on what you really need to get out of him.
Yeah, you know, you saw a lot of gyrations by him on the stand. He was picking up papers. He was, you know, seemingly agitated, which I think actually inures to the benefit of the prosecution because it's consistent with the statements that the police officers were making. I was a little surprised the prosecutor gave up on that previous CIA statement from all those years ago because, again, credibility of the witness and the manner in which he's responding to law enforcement and or authoritative jurisdictions, I think goes to credibility. Credibility is always relevant at trial. But yeah, the speaking objections, look, I've been with judges that have allowed it to happen. And when given that opportunity, I try to obviously influence the jury with respect to my speaking objection. And, you know, if a judge decides that, no, Mr. Bianchi, I'm not going to allow that piece of evidence in, it's kind of hard to unring the bell once the jury heard it. So in today's normal parlance, that doesn't happen. You go to sidebar, judge makes an evidentiary ruling outside the presence of the jury, and then you move on.
Yeah, look, a lot of different ways to do this. We're watching it a different way in court in Georgia. But look, we're going to take a quick break. We will be back with hopefully closing arguments in Foster and also Anthony Kirkland's sentence in a moment. And welcome back yet again, folks, to Law and Crime. We are anxiously awaiting a verdict in a death penalty hearing in Cincinnati, Ohio, against Anthony Kirkland. Will it be life in prison without the chance for parole, or will it be the death penalty? Michael Bachner is still here with me in studio. Bob Bianchi is still on the line. So, gentlemen, let's break this down. You've got a guy who's been accused or admitted to playing a role in 5 separate homicides. The facts are about as bad as they get.
Yeah, they're pretty brutal. The defendant did admit some medical testimony that was very detailed about an abusive upbringing that somehow had some impact on the synapses in his brain when he was very young, and how that would have probably given some predilection to these types of offenses. He's trying to throw as much as he can to hopefully get some sympathy from a jury. There were some mitigation issues made, but these were really horrific murders, and etc. And you know, one of the issues that came up last time during the course of the testimony was the fact that many of these bodies were burned, which I thought was, you know, certainly egregious. But one of the issues was, and I don't know exactly what the testimony was, I must admit, but to the extent that the bodies were burned post-mortem, I'm not so sure that if I was a defense lawyer, I think they were burned post-mortem, I would have been admitting, I would probably have objected to any of that testimony coming in, because at the end of the day, the issue is, was the murder itself brutal, and which was brutal enough, but the burning part of it, to the extent that it was post-mortem, I think was overly prejudicial to the defendant in this, and something he may raise. But these were pretty brutal homicides, and 2 jurors have already found him responsible enough to give him the death penalty. I'm not expecting it to be any different, but you never know.
Yeah, we could sit here and predict all we want, but of course the minds that matter are the ones that are probably filing back into that courtroom right now as we speak. We see the defendant seated. We're waiting for everything else to get rolling, adjusting his collar there. Bob, I'd be hard-pressed to, off the top of my head, name a defendant who has listened to this once before and may be facing it yet again here. He listened as a previous jury back in 2010 said, you get the death penalty. And he may be hearing it again in a matter of moments here.
I think he's going to be hearing it again, Aaron. You know, we always do the speculation as trial lawyers. Michael knows this very well, how fast the jury's coming back, not coming back. You made a very astute comment about how long the jury verdict sheet is, and it takes a lot to go through. It's a lot of heady law, and they want to be accurate. It's my opinion that this jury went in there, and they were basically extraordinarily convinced of what their verdict was, filled out the paperwork, and in a case of this magnitude, with this horrible, disgusting kind of crimes, I can't imagine anything other than death. But I think Michael brings up a good point. We talked about this before. I mean, there's some evidence that's allowed to be admitted here, even including all the other people, where it's almost double counting crimes because he's been sentenced on those other crimes. In a lot of other jurisdictions, they only have aggravating and mitigating factors with respect to the particular victims of that particular case. So, I mean, I think there's going to be avenues, believe it or not, of appeal again here, Aaron.
Well, that could be. I mean, you know, a couple of the statements sort of towed almost up to the line that we heard in the first case. So is it possible that this could go up yet again? And is it possible that the court could turn around and flip it yet again? It's always possible. It seemed to me that prosecutors, though, Michael, and I'll throw this your way, were really careful to read from a script almost all of the way through this. They seemed to not want to deviate too far from what they knew the case law specifically allowed them to say.
Right. They were advised by the appellate court when they reversed, basically, that they're looking at this very carefully, and as horrendous as the offense may be, they're going to make sure that a defendant, if he's going to be getting the death penalty, that the deliberations were completely forward and not at all impacted by any prejudicial stuff that the prosecutors may have said. But there was a script. But this is just an indication of just how expensive it is to put people to death, frankly. This is going to get appealed again. It's going to get kicked back again. They could try and go to the federal court as well.
This probably several times over again.
Right.
There's going to be an initial one. There's going to be a last-minute one. There's going to be a Habe. There's going to be everything. Yeah,
really what gets the death penalty here is a taxpayer. The other ones are getting killed. This is really just an enormous amount of money, millions and millions of dollars that are spent. In some jurisdictions like Texas, they complain it's just too quick. You know, they're trying to strike a balance, but the court here certainly sent back a message to the prosecutors. We're looking very carefully at what you say.
Bob, I wanted to ask you about this. This trial was basically a argument, a battle of the experts, as we were saying this morning here on Law and Crime, where the defense had one expert, the prosecution had another. Apparently, these two were adverse to one another as experts in a number of courtrooms, and both sides are just pointing the finger, saying the other guy's completely, you know, incompetent, is just making things up. You know, how do juries take this stuff? Do they believe either of them? Do they believe neither of them? Or do they just turn around and try to judge it based on the gravity and circumstances of the individual crime?
I think it's latter, Aaron. I think that they look at the gravity, nature, and circumstances of the crime, absent expert testimony that would show something with such great mental debilitation that the person could not have understood or appreciated the nature of the crime. You got 5 bodies here. They're sexually assaulted, young girls in the 2 instances that we're here now. Bodies are mutilated, burned afterwards. There's 2 experts have differing opinions. I think they cancel each other out. And in the end analysis, they listened to his confession. He was cogent. He was straightforward. He gave some wild and crazy explanations as to why he did the things, very uncaring, in my mind, almost deflective. His allocution, or that is his statement to the jury to spare his life, essentially was like, you know, hey, if you kill me, you kill me. I get it. I don't deserve to live. And I think that's exactly what the jury's going to say, that we're going to accommodate your request.
You know, it's interesting you brought that up, Bob, because that's exactly where we're going to go right now here on Law and Crime, is back to that allocution. Again, this is a right of criminal procedure in the state of Ohio. Defendants get the right to do one of these allocutions, one of these statements. It's unsworn, so he can basically say what he wants. We were going to play that, but it looks like everybody's standing up, so we may have the judge coming back into court right now. Want to listen to this for just a second, if I can, to see if we're going to get sound in this case. This sounds like we're possibly getting the jurors walking in, so I think we're going to stay here in analysis for just a second, because we may be getting the verdict handed up to the judge in just a matter of seconds here in the Anthony Kirkland case in Cincinnati, Ohio. Again, two particular victims, a question as to whether or not the defendant gets the death penalty or whether or not the defendant gets life in prison without the chance at parole. We're going to go straight to court because we have sound. Those verdicts came in, as you just heard, the jurors handing up to the judge a recommendation of a death sentence in the Anthony Kirkland case. Bob Bianchi on the line with us, Michael Bachner here in studio. Michael, you and Bob both sort of said, well, it wouldn't be a surprise if this is where we go, and it's exactly where this jury went. Yeah,
the defense lawyers didn't seem shocked by it, nor did the defendant. There was really no reaction by him, and he may have been told not to. He's been through this before. Defense lawyers didn't seem shocked by the verdict, and I don't think the judge was. I don't think anyone was, frankly.
You know, Bob, we had victims who were young. They were 13, 14 years old in this particular case. The previous victims were of different age brackets, but you've got young victims here. They were young teenage girls. They were burned very severely after this. So it seems perhaps jurors were honing in on some of the heinous nature of the crimes here.
Yeah, I mean, and that's one of the greatest aggravating factors that you can have is that particular part. I mean, because every single juror could put themselves in the position of either the women or their children who are innocent people going about their business, and some maniac who's committing multiple murders is luring them, dragging them, sexually assaulting them, mutilating their bodies afterwards. Listen, I've done homicide work my entire career, Aaron, and, you know, many times I prosecuted people and put them in jail for very, very long periods, life sentence, life without parole. But usually you can understand in most circumstances why it is a person murdered. It may not be a legal defense. It may not be something that you shouldn't prosecute. But a guy like this is like one of those 1 in a million guys. This is one of those guys that just has got something going on in their personality, whatever the flaw may or may not be, whatever his background was or wasn't. Lots of people have flaws. Lots of people have bad backgrounds. This is a guy that this jury knows, if given an opportunity again, will kill again. He had no redeeming factors, no remorse, in my opinion. His allocution was almost arrogant and obnoxious. There was nothing upon which even one juror could sit there and say there's a redeeming, mitigating factor here that would outweigh the aggravating factors. Death was a fait accompli in my mind.
Well, you know, Bob, I heard the inner prosecutor coming out of Bob Bianchi there for one of the few times I've seen it unadulterated here on Law and Crime. But look, we're continuing to pay attention to a couple of trials here on Law and Crime. We're going to take a quick break. We'll be back in just a moment. And we just saw the tail end of the prosecution's closing argument in the Stephen Foster case in Georgia. We have two extreme experts here to help us break this down. Bob Bianchi is on the line from New Jersey. Michael Bachner is here in studio. I'm going to throw this on the table. We covered a case here, I think it was last summer, of a doctor in a different state, and there a sample, a blood draw, just like this, was thrown out because in that state, the law requires refrigeration, because if it's unrefrigerated, apparently, and the alcohol in it ferments, sort of like warm beer, apparently, with any organic substance. And in that case, prosecutors had to drop the top charge because they didn't have a sample that was refrigerated. Now, in this case, we're in a different state where apparently the law doesn't require refrigeration, but here, they're saying, oh, it doesn't matter whatsoever. We can let this stuff sit around basically indefinitely before we test it. So, Michael, forgive my stupidity. I'm not as smart as apparently other people think they are, okay, to poke a little bit of fun at the prosecution's closing there, but which is it?
Well, she made a very good point, and that was that according to the testimony, if you would have take as true what the defense was arguing, it would have caused the blood alcohol level to decrease, not increase. So she's saying that even if we didn't do it right, it means that really his blood alcohol would be higher than the 1.03 that we got, not lower.
Well, that's kind of funny because, again, I'm remembering back to this case in Ohio of the surgeon who was accused in a drunken boating accident, and there the science was if you let it sit around, the blood alcohol level increases. She's saying it decreases. I realize it's a different state, but science doesn't change when it crosses state lines. I mean, the rules of physics, the rules of science tend to be pretty constant. I'm just sitting here wondering, what is it? Well,
to me, the defense should have called an expert on this. It doesn't sound like they did. If in fact that's the argument they wanted to make, they should have called to someone to say that that's the impact of letting it sit. It doesn't seem like that testimony was brought out, and the defense probably should have raised it. The prosecutor seems like she did address it, and that's the testimony that's on the table, and she said that that's what the defense left out of their summation. Now look, could a jury go back and say, you know what, you didn't follow the rules, we don't really care? In New York, you've got a rule that you've got to give a breathalyzer within 2 hours of an arrest. If you don't, the judge has the discretion to ignore the breathalyzer also, because the science says after 2 hours it's no good anymore. So there are these kind of rules that have to be, that are kind of jurisdictionally sensitive about different areas of the law. I agree, science is science, but apparently the science that she has wasn't rebutted by the defense, so we'll see what happens.
Or if it was, it wasn't done very well. So Bob Bianchi, you're still on the line with me. Bob, which science am I to believe? Am I to believe Ohio's science, or am I to believe Georgia's science? Which one is it?
Am I to believe that water soaks into a grit faster on your stove than anywhere else in the world? You know, Aaron, you make a great point. And there is this oddity about expert testimony that comes in that I think a lot of times is, you know, we have the Daubert rule and when expert testimony can come in, one saying the blood dissipates, one saying the blood, you know, ferments. And it's unfortunate that with something that would be a relatively straightforward scientific fact, in many instances, you have a battle of the experts in courtrooms that are looking at the same exact physical evidence. And one will say the water goes in a grit just as fast in New Jersey as it does in Alabama, and you get another guy that says, no, it's absolutely different because of atmospheric pressure, and I'm getting paid by the defense.
Well, you know, Bob, this raises another big question, and that's what the proper cheese sauce ratio is on a pizza. Sorry, folks, it's an inside joke, but look, we're going to get you folks caught up on the top crime stories of the day. We're going to be back to discuss a lot more about the Stephen Foster case in just a second. We are back, folks. We're talking about the Stephen Foster case in Georgia. This is a case where a doctor is running as a Democrat for U.S. Congress. He leaves an Applebee's without his lights on at about 1 or 2 in the morning. He gets pulled over, and the officer accuses him of drunk driving. He says he only had 2 gin and tonics, along with some other non-alcoholic beverages, and that it took him hours to consume them. So he says, how is it that I could possibly be drunk? The defense attacked the state's science, saying, you took a blood draw, you refused to give me my legal right to an independent blood draw. Okay, so strike 1 against the state for that. And the second strike against the state is apparently they sat on the sample for a couple of months before actually doing the testing. And it seems relatively certain from the record right at this moment that it wasn't refrigerated. So the defense is saying, well, the reason that the numbers are so high is because the alcohol that was in the blood was fermenting and it was multiplying in the vial for 2 months before it got tested. Bob Bianchi is on the line with me from New Jersey. Michael Bachner is here in studio. So look, this is a pretty straightforward case for the jurors. They just have to try to figure out what science to believe and then whether or not to believe the officer. And I say straightforward because it's short. They don't have to go through 20 days worth of evidence. They don't have to go through 20 days worth of testimony. This case started this morning. It ends this afternoon.
Well, yeah, and what's interesting is this rule in Georgia, apparently it's not the kind of rule that a judge has the right to say, you didn't do this, therefore I throw the case out on my own. In other words, it's not one of these dispositive things, well, you didn't give the guy the right to his blood test, so the case gets kicked. Apparently there's some discretion there where the jury can still make a determination that even though he didn't get the blood test, the case can still go forward, because it is. So, you know, as far as what happens here, the jury, as far as I know, only has 1/2 of the science, and that's the science that the prosecution put forward. Doesn't seem like there's any science from the end, unless the defendant himself, who was a doctor, may have testified as to what the science was. But it looked like the judge was trying to curtail that testimony when he was on there, that wouldn't let him testify as an expert because he's the defendant.
It sort of raises all sorts of interesting logical conundrums here. But look, he tried to get into why he wanted a specific test done at a specific hospital, and he said it's because the results come back right away.
Yeah, he said it's a better test, it's a more reliable test, and you guys wouldn't let me do it because you didn't really want to know what the truth of the matter is, which really goes to the motive behind this, and that is this a stop that this police officer knew who this defendant was and decided that he wanted to interfere with his political aspirations? Was this an officer who kind of screwed up and, you know, was embarrassed about it and tried to cover it up for some reason unrelated to who he was? But there has to be some motive here for, as far as the defense is concerned, either a negligent officer just didn't do his job and should get kicked out, or is there some ulterior motive based upon the political aspirations?
Yeah, I'm really curious about this, Bob. I thought that the political aspirations of the defendant were going to play a little bit more prominently here. Maybe that was excluded on relevance, but look, at one point, one of the articles that I read about this case suggested that the defendant heard the cops sort of proverbially high-fiving one another. Hey, wait a minute, we got that Stephen Foster guy who's running for Congress as a Democrat in Georgia.
Yeah, and if this was in fact provable, and this was supposedly done over the police radio transmissions, which are typically recorded, that obviously would be a big factor as a defense attorney I would bring out. I know the defense attorney, by the way, who did a very good job with a short period of time, brought out the idea from the other one of the police officers that there wasn't the odor of alcohol and some of the other things that you would typically see in a DUI arrest. And then there was that big issue about, was he swaying or not swaying based upon the videotaped evidence and the way the report was written. So I, as a defense attorney, if I were attacking the prosecution's case here, would definitely be going for the fact that there was a motive. As far as going after him in particular, that's the reason why they didn't take him to the hospital, to be able to get a secondary blood result that would have been, in his mind, more accurate. It's why they put in there that he's swaying when the videotape, they're alleging, does not depict the swaying. And therefore, the observations of the officers as to DUI or probable cause to make the arrest were flawed. And if that's so, then the actual scientific evidence may be flawed. And the bottom line to that, Aaron, as a final point, is that it is not an even playing field. It is meant to be, and rightfully so, that prosecutors are able to prove their case beyond a reasonable doubt, and that means by putting credible witnesses on and a credible investigation, dotting I's, crossing T's. An innocent mistake, jurors will get past that. Any idea that there's some nefarious actions, they will give the benefit to the defendant.
Well, you know, I think it's sort of strange that you've got this recording and the officer basically saying what apparently is not on the recording. Maybe the recording is going to be the thing that settles this. Does the guy look drunk in whatever video they have of him from that night? Maybe that's the dispositive thing about this. And we keep going back to whether or not this guy should have retained counsel earlier, Bob, because, look, you brought up some great points about what should have been done. Where are the police radios? Where are the recordings of those? Is there anything, funny said in those? We know that there was some funny business going on because there's a lot of joking at the scene. But
right.
Look, could there have been a more thorough investigation done had this defendant retained counsel rather than promise to defend himself? Those are unknown questions at this point. We can only wonder. But look, we are going to pitch, I believe, to the prosecution opening statements in the Stephen Foster case, the case that we're talking about. Let's listen to how the prosecutor tried to get jurors into this case first thing this morning. Some of the defense opening statement in the Stephen Foster case out of Dalton, Georgia. This is way over in western Georgia near Chattanooga, Tennessee. It's just south of Chattanooga, or southeast, I should say. So it's in a more rural part of Georgia. And the accusation is that a Democrat running for U.S. Congress, who used to be a medical doctor, was driving drunk. That's the accusation. It's just simple as that. Michael Bachner is here with me in studio in New York. Bob Bianchi is on the line from New Jersey. So we're continuing to break this case down as jurors mull over whether or not this is going to be an acquittal or a conviction. You were doing some more research into Georgia law on whether or not this right to an independent blood test is an absolute right in the state of Georgia. And apparently it's not quite as clear-cut as we would like to think.
Yeah, a defendant who gets stopped in Georgia for DWI, if he agrees to take the test that a test that the police officer requests, then has a right to request an independent test. If he doesn't take it, then he doesn't have that right. then once he makes that request, the officer has to act reasonably in giving him that test. So the court will then look at whether or not the request was made, how far was the place he wanted to go, what were the accommodations that were available, was the police officer under some other time restraint or constraints, etc. So it's a reasonable test under the judge to determine whether or not the denial of the defendant's right was reasonable under the circumstances.
Well, if they're already there at the hospital and he has a right to it, then does the judge just look and say, well, the state's test is going to be fine because it was drawn in the sort of facility that you sort of agree to be at?
Well, the issue is, I'm not sure if the doctor wanted the test done at that same facility or wanted to go to a different facility. I'm not sure of the answer to that, but certainly I would agree with you. If it had to just be done in that hospital and it was some other type of test, and the failure to give it, it sounds to me like the judge would have precluded the use of the original test, but that didn't happen. The judge must have made some determination that there was something unreasonable about the defendant's request.
I'm really curious about this law. I'm going to have to dig into this a little bit more myself. Bob Bianchi, I know you need to hit the road, so final thoughts on the Stephen Foster case before you take off, Bob.
Well, you know, this defense attorney did a really good job, I think, with the evidence. And I just have to say this. The idea that a person has a right to an independent test that the police reasonably have to accommodate is a very progressive law and a good one. I've been involved in too many cases, even as a prosecutor, prosecuting blood cases and DUI fatalities, where people don't have that opportunity to do that. So it was, I think the reason it was probably not precluded was that the judge said you could argue.
Bob, I think we might have to cut you off there. We're going to go to a break, and the connection's getting a little spotty, so we'll see you next time, Bob. We're going to take a quick break. We'll be back with more in a moment. Welcome back, folks. Something very strange happened during the break. They came back with a verdict in the Stephen Foster case in, I think, lightning speed. The verdict, as it's being reported to me, was guilty. This jury went back into that room, looked at one another and said guilty, and basically walked right back out into the courtroom. I think that they may have been back there maybe for 10 or 15 minutes. I'll have to go double check the exact time, because after jury instructions started a little bit after 4, they probably didn't get back there until about 4:15. They must have announced a verdict probably 10, maybe 5 minutes ago, came back out. So I think they deliberated maybe 10 minutes in the case of a candidate for Congress on the Democratic ticket being accused of drunk driving, where the state didn't accommodate blood tests and where video basically contradicts what one of the officers said. So this is a bit of a surprise. Michael Bachner here in New York City with me around the table. What do we make of this? I mean, this is lightning fast.
I think the jury just went in and looked at what the science was as far as what they had, and I think these are the dangers of defendants who decide that they can do as good a job as a lawyer can do. A lawyer would have probably got in there pre-trial and tried to have done all these science-related issues, would have made perhaps particular motions that maybe this defendant never made regarding the admissibility of the other test. Who knows what he did or what he didn't do, but you know, if I go to a doctor and say I'd like to operate on myself, he'll tell me I'm crazy, right? But a lot of people want to be their own jurors, and this doctor decided he could be his own lawyer until it sounds like he didn't get the prep that really this trial needed, and maybe the result would have been different.
Yeah, we're going to clip that verdict and play it back for you folks in just a couple of minutes, but let's dial back to some of the previous testimony. This is Justin Smith. He's one of the police officers there in Dalton, Georgia, who testified in this case. He was eventually recalled and attacked on the stand by the defense. Well, let's listen to what he said on direct testimony earlier today. That was testimony from the officer who pulled Stephen Foster over after Foster said he'd been drinking at an Applebee's. Apparently, he said he had a couple of gin and tonics at Applebee's, but several hours back before that, he had had some beers. Now, does this all add up to the .103 that apparently the breathalyzer caught somewhere there at the scene? And why did the vial not get not refrigerated? Why didn't it get tested promptly under state law? Michael, we have a lot to wrap our heads around with, but we know that the verdict came back guilty here.
Yeah, look, these are issues that should have been raised, and I guess the lawyer who came into the game late raised as well as he could under very short notice. But like we said, it may be that had these issues been raised more timely, in a more efficient manner with a lawyer who knew it, earlier on, maybe the results would have been different, because there were issues about how the test was done, and the prosecution has an obligation to demonstrate that we would call chain of custody was done properly, that the testing was done properly, that it lived up to the appropriate circumstances. And I've tested I haven't done a lot of DWI cases, but I've done a bunch. And you know, you immediately put in for the scientific analysis. You get your own person to go in and test their results. There's a lot of stuff you have to do if you're going to want to contest a DWI evaluation. And frankly, not just for his own political aspirations, because frankly, I'm not so sure a DWI conviction really is a death knell to someone who wants to be a congressman anyway. But to the extent that it's certainly it's certainly better not to have it. But at the end of the day, you know, this is something that is serious. You can go to jail for DWI in Georgia for up to a year, I think you were saying. Mm-hmm. And you know, this is a serious stuff. And you get caught with a second one. That first one is used as a predicate to send you to prison for even longer. So the ramifications can be very severe. And
yeah, I mean, there's a fine, there's all this other stuff attached to this, but look, we've got the verdict clipped, and this verdict came back lightning fast, folks. We do have it clipped. We're going to play that now for you so you can listen to the verdict as it was read about 10 minutes ago in the Stephen Foster case.
You want to go ahead and be seated, please? Verdict reads as follows. We, the jury, find the defendant guilty. It is signed Jonathan E. Nuno, dated August the 6th, 2018. Any objections for the verdict?
No, ma'am.
No, ma'am.
All right. Anything for a discharge of the jury, counsel?
Not on behalf of the state.
All right. Ladies and gentlemen, thank you for your service as jurors. I routinely tell juries, because I truly believe this, that the United States of America has the greatest justice system in the world. Now, it's not perfect because it involves human beings, so it's far from perfect, but what makes the justice system in the United States great is that we count on our citizens to come forward and serve as jurors. We don't have professional jurors. We don't have kings or ayatollahs or politicians or anybody else that all they do is serve on juries. We count our citizens to come in and do their duty and serve as jurors. So with that, I want to thank you for your time and your service.
And that's the verdict as it was read, and of course the proverbial thanking of the jury that we hear in every case. The Stephen Foster case ending with about 10 minutes of deliberation in a drunk driving case that started today and ended midway through the afternoon. The case of a doctor running for U.S. Congress who was pulled over, accused of drunk driving, said he didn't do it, challenged the state's test, challenged the officers on the stand with video evidence saying, hey, look, the video doesn't say what your report says. Ultimately results in nary a slight deliberation from jurors there and a guilty verdict. A surprise that it happened that quickly because, look, Michael, and we'll get to this after the break, I guess, it seems like they didn't even really tear into whether or not this test was done properly under state law. We're going to take a quick break, though. First, here on Law and Crime, we'll be back with more analysis in the Foster case in just a moment. We are going to wrap up our discussion of the Stephen Foster trial, which started today and ended just a few moments ago with a guilty verdict for a doctor running for U.S. Congress in Georgia, the guilty verdict on a drunk driving charge. So Michael Bachner is here. My last question for you. If you had this case and you had it early, what else would you have done, and what else should this defendant have probably done here?
Well, first of all, you speak to your client, say how much money you're willing to spend, not just on the lawyer, but on the experts. Do we want to spend the money on a scientific expert who would say that this is the impact of them not refrigerating it properly? Do we want to have an expert talking about what impact this doctor may have had? Apparently he had some other medical issues, ADHD and things. What are the impact perhaps on you as far as swaying, or were you swaying or not swaying? Were you suffering from any other disability that could have given the same appearances that, of someone drinking? And I had that at a trial once where we were able to put medicals in to show that defendant's heart medications cause the same type of reactions under stress that someone drunk may have shown.
Those are interesting observations. Certainly a well-prepared attorney with a cooperative defendant would have done that. You also mentioned, hey, look, let's dig into the transaction receipts at Applebee's.
Correct.
Let's figure out what his credit card's been doing. Was he out drinking at a number of different places? Who was serving him? Does that person get a chance to testify? Is there a record of what his bar tab was that night? All of those things could potentially have been helpful here.
Yeah, when he's walking out of the bar, is he stumbling? Does he look okay?
Is there surveillance footage?
Exactly. Was he slurring his speech? There are all of these other factors that a prepared lawyer would have done or should have done. And look, once you make the determination you're going to go to trial, you do it right or you don't do it at all. And this defendant made the decision to exercise his constitutional right to go to trial, but it looks like he was just not fully committed to doing that until try to get committed at the very end, and now looks like he's going to get committed.
Well, yeah, I mean, that's one way to put it. Your commitment to the word commitment is applaudable, Michael. But so look, I mean, the attorney said this morning that he had just gotten on the case and he was cramming for it. And some of the pre-trial press was indicating that this defendant said he wanted to represent himself. So maybe he retained counsel right at the last minute. Is that enough time to prepare? No, it's not, if that's indeed what happened. I'm just putting two and two together here, thinking that may have been what went down. But we had another verdict come in today, and that was in a case we've been watching for well more than a couple of weeks here, the Anthony Kirkland case in Cincinnati, Ohio, the case of a serial killer who was accused or convicted, or I should say, was convicted or admitted to playing a role in 5 homicides over a number of years. He was being retried in the penalty phase on 2 of those killings. Jurors came back with a death recommendation in that case. We're going to go back, though, and re-listen to some of the prosecution's closing argument from earlier this morning, because prosecutors did not mince words in describing the defendant's actions. Sorry about that, folks. Apparently the sound was a little bit off in that clip. We're going to try to rectify that, bring another clip in. But look, this, again, not too much of a surprise for this defendant who was sent to death row back in 2010, only to have the sentencing part, the penalty phase of the trial, flipped by an appeals court. And that itself was a weird procedure, because the Ohio Supreme Court took a look at Kirkland's conviction, took a look at his sentence. They said, it's a problem, but we're not going to flip it and order a new hearing. Then the Supreme Court reconsidered and said, wait a minute, no, this is bad enough to require a new hearing. And what I was always told by justices who sit on Supreme Courts is, don't ask us to reconsider our cases unless there's a huge problem, because we don't reconsider our cases very much. Here they did that. That's extremely rare.
You know, they may have, yes, it is. And they may have done that thinking that it was the type of error that could have resulted in federal review anyway. And we might as well just keep it at home, give this guy a second chance at the apple. Let's fix it now instead of the delay factors. And they did. They went back and they essentially told the prosecutors what they shouldn't say. And look, what the prosecutor said was fairly egregious. He basically said, if you don't kill this guy, you're giving him a freebie because he's already killed 2 people already. So, you know, what's the deterrence? It's kind of it's the type of argument you shouldn't be making as a prosecutor.
It really rubbed me the wrong way when I read it. And I know a lot of people are like, well, look at how bad this stuff was that he did. He killed these teens, set them on fire, stole their goods, and basically almost bragged about it to police. And my response back is, okay, well, you didn't need to go too far to get this guy to the sentence that you wanted to argue.
Yeah, as a prosecutor, you can't lose it. You've got to just stick to it. The issue was what happened on these 2 homicides, and you can't make arguments about, you know, if you don't punish him here, he's getting the others for free, because that's essentially asking them to punish him again for what he's already been sentenced for it, and in the past. You can't. And there was a line that the prosecutor used in this trial, which I think is going to be point 1 of the appeal, which is when he called the defense lawyer's expert a charlatan, and said, isn't it a fact that you have a reputation for being a charlatan? I mean, that's a horrible question to ask. And I'm sure it's going to be, I don't know if it was objected to at the time, but I do know it was asked. That's a very, very, just an improper question.
It was a pretty harsh case all the way around. Look, we're going to listen to a little bit of the defense closing in the Kirkland case right now. It's a little bit of the defense closing argument in the Anthony Kirkland penalty phase case for a serial killer in Cincinnati, Ohio. Michael Bachner, the defense gets a chance in these hearings to basically throw up any mitigator that the defense can possibly think of here. Sexual abuse, emotional abuse, physical abuse. When this defendant was a child, that's what he claimed, and they ultimately claimed he basically had a defective brain because of it.
Yeah, they called some significant witnesses who did, the woman, a doctor who they called, the PhD, did a wonderful and a really detailed idea of how the brain works, the synapses, they weren't firing, the development, the fact they didn't get the attention, and how that actually had an actual physical result in the way his brain developed and caused this type of behavior. So they certainly did their job for this guy. They did what they could do. They presented the evidence. At the end of the day, the jury looked at him and said, you know what, these crimes are heinous. There are a lot of people who have your type of upbringing who don't go around killing people, so out the window with that one.
Ended the way you do. Hey, we have to say goodbye. Michael Bachner, great to see you here at Law and Crime. We're going to sign off. We'll be back live starting at 9 a.m. here on the Law and Crime Network.